Hello, I'm Professor Pat Tolan, and this is my family. Today I'm going to be talking to you about family law as it's tested on the Florida Bar examination. Testable topics include jurisdiction, which is a threshold inquiry in every area of Florida law. We'll be focusing on divorce and dissolution as the most tested topic in family law, specifically looking at the PEACE analysis. P stands for parenting plan, E stands for equitable distribution, A stands for alimony, C stands for child support, and the E stands for everything else. Threshold question for jurisdiction of the courts is whether or not there are grounds for divorce. Certainly in Florida, as a no-fault divorce state, the subject matter jurisdiction is easily met. Either spouse, if a Florida resident, can demand a divorce. Justifications for dissolution of marriage include the irretrievable breakdown of the marriage or a lack of mental capacity. Be sure when you're considering jurisdiction to consider the jurisdiction over the parties, jurisdiction over the subject matter, and especially jurisdiction over the children, since the Uniform Child Custody Act applies and Florida will be governed by a requirement that the child have resided in the state of Florida for 6 months before Florida will have jurisdiction to decide the parenting plan and child support issues. Also, don't forget about venue. The venue typically will be where the parties reside if they're presently living together, or where one of the parties reside if they're presently living apart. The PEACE plan. The P in PEACE plan again starts with parenting plan. The parenting plan is the place where you should begin your substantive analysis of family law issues. The reason is that the parenting plan, to the extent it allocates an unequal distribution of time between the parents, will impact later equitable distribution potentially, may impact alimony, certainly will impact child support, and may impact everything else. So we want to start with the parenting plan. Key here is to refer to the plan as a parenting plan. Don't use the old buzzwords custody and visitation. Instead, the goal of the parenting plan is joint parenting, which would encompass an equal right to the sharing of the children. Ideally, this would be complied with in a 50-50 timeshare agreement. However, the goal is the best interest of the children. And so many factors are considered to determine what's best for the children. And the best interest of the children will drive the parenting plan to include the timeshare arrangement also. The second main consideration, and this applies in any divorce or dissolution, whether there are children or not, would be the equitable distribution of the marital property. The presumption of equitable distribution, as the name suggests, would be an equal distribution of marital assets, 50-50. However, the court will consider many factors, such as if one spouse gave up the opportunity to work so that they could stay at home and raise the children and take care of the household, or if one spouse worked full-time so that the other spouse could go to school to gain an education. So there may be an unequal equitable distribution. Sometimes this factor is simply referred to as ED, which is short for equitable distribution. After the equitable distribution and the parenting plan are determined, then it's appropriate to consider whether or not alimony is required. Alimony will always be based on the needs and the ability to pay of the two spouses. The trend in alimony nationwide, not just in Florida, is away from permanent alimony. In lieu of permanent alimony, what the state has done is looked at several different mechanisms for temporary alimony. And we'll go over those in more detail during that portion of the course. Child support, as the name suggests, is the parent's obligation to provide support for the minor children. This obligation extends to the extent that the parent does not have at least a 50-50 share of the timeshare, and to the extent that one parent earns considerably more than the other parent. Statutory formulas set the general range for child support, and the judge has discretion within that range to establish the appropriate amount of child support. The E in PEACE stands for everything else. A typical consideration is whether one spouse should bear the other spouse's attorney's fees, and whether one spouse should be made to bear all of the costs of the divorce. Typically, a spouse in a better financial position, especially if the other spouse is unworking, may find that they're covering the attorney fees for both attorneys as well as the court costs. The next sessions will consider the details of jurisdiction and the various elements of the PEACE plan. Thank you.